Do you want to know how long a copyright lasts? Do you want to know whether a work that could have been copyrighted was never registered? Do you want to know how to determine whether a copyright was not renewed? Do you want to know the rules for works from different foreign countries? Do you want to find out whether a use you have in mind would constitute fair use under the law? Are you going to deal with a work that has derivative works? These are all subjects in this series of videos. This video is on derivative works. At the time that this video is being made, there is debate over whether a poster that became very familiar to Americans before the 2008 presidential election was an infringement. An artist named Shepard Fairey based his posters of candidate Barack Obama on a photograph produced by the Associated Press on which the artist did not seek permission and did not have authorization. You are not seeing that artwork here. You are not seeing that photograph here. We've mocked up something that sort of looks like Shepard Fairey's artwork, but uses different color schemes and, most importantly, is based upon a different photograph. This is the photograph. It's a still frame from a speech given before Congress, and it was shot with the United States government's own camera. That latter fact is important because it means that the American people own the image, and there is no copyright infringement involved in using it here. The artwork that you can see that was based upon the photographic image was made specifically for this video, and thus it does enjoy copyright, but it enjoys copyright held by the maker of this particular video. That means all of you watching it, all of you who may receive it, all of you who might simply receive an image based upon it would be infringing copyright were you not to seek and obtain permission from me. Now, the unmodified image is an entirely different story. I no more have proprietorship over this image from the United States government's camera than any other citizen. Therefore, the rest of you are entirely within your rights to use the unaltered image. The basics are this. When something is produced by the United States government, it's free for anyone else to use. If something is produced by a private party, but copyright expires or is invalid, then and only after that point in time can anyone else use it. However, as long as a private individual or private organization has a valid copyright, they have the exclusive rights that copyright entitles them to. It's not only United States presidents and candidates for the presidency who might appear on the United States government's cameras doing the work of the United States government. There are 435 congressmen and 100 senators, and their work for the United States government also is not subject to copyright, and their appearances on the Senate's camera, the House of Representatives camera, or on their congressional websites are free for the citizens to use. Here is an image of President Obama's leading opponent in the 2008 election, and here is his image, heavily modified. As you can see here, this longtime senator representing Arizona is seen with beautiful Arizona desert colors.
I guess you don't have to point out that the altered image is the property of the artist who made it.
Yeah, I would think so, if it was a private party who did it.
Yes, indeed. As with the altered Obama image you saw earlier, this image of Senator McCain was made specifically for this video.
Can we guess also that the photographic image is something that anyone can use?
I'm not sure you can say that.
The point here is that if you start with a government source image, the original image would be uncopyrighted. Only the altered image is subject to copyright.
You keep saying if. Is it the case that the original image is not a government image?
Indeed, this is an image I shot as a private citizen using my own camera while just a few feet away from the senator. So the original image is protected by copyright, just as the altered version is also. However, had a government source image been the original, then the copyright status would be the same as with the Obama image shown earlier in this video. The original government source version would belong to the public, while the altered version is owned by the artist. Section 103 of the Copyright Act, as it has been in effect since 1978, has a clear passage indicating the relationship between the old work and the derivative work insofar as what degree of copyright protection each is to get from the other. The general thrust here is that you cannot attempt to use the newer work to make the rights in the older work last longer or come back into existence. The movie company that remade A Star is Born in 1954 found this out when they tried to use the copyright in the 1954 version, which was a valid copyright, to try to bring back copyright in the 1937 version. The court didn't buy their argument. The 1937 version of A Star is Born had gone into the public domain, and the fact that the 1954 version was still under copyright did nothing to revive the rights in the 1937 version. Had the copyright status of the two works been opposite, had the older one still been under copyright and the newer one been the one to have lost copyright, the older work would have been the underlying work insofar as the newer work was concerned, and the owners of the newer work could have used that fact. And in this hypothetical situation, the owners of the newer work could have told anybody who attempted unauthorized use of it, hey, wait a minute, by copying the newer work, you're violating our copyright in the older work. You can't do that. The movie company that would still own the rights to the 1963 film McLintock thought that they had a different case. After the 1963 movie went into the public domain for lack of a copyright renewal, the company thought that they could sue unauthorized use of the film on the basis of the screenplay in the movie, which they asserted was still under copyright as an unpublished work. In this way, the case of A Star is Born is different from the case of McLintock because unpublished works involve a different rule of copyright than do published works. There's an entire video in this series about unpublished works. However, as far as the verdict was concerned, it was A Star is Born all over again. The court reasoned that the unpublished screenplay had, to some extent, become published. Specifically, those portions of the unpublished screenplay which became part of the published movie were thereby published when the movie was published. Therefore, those portions of the screenplay could not form a basis in copyright law to prevent unauthorized use of the movie. Then again, the portions of the unpublished screenplay which did not go into the movie remain unpublished. So those parts of the screenplay do continue to enjoy copyright. Not that it did the movie company any good in its attempt to try to get a stranglehold over all future exhibition of the movie. Proving that all cases of this variety don't end up the same way and that the movie company wasn't through taking people to court, they reasoned that what went into the public domain was the widescreen film that had been published in 1963, and that when they adapted the movie into a pan and scan version, which had a separate copyright, that pan and scan version was a separate derivative work, and that it continues to enjoy copyright, quite apart from the lack of copyright in the widescreen version. In this particular case, the court saw this reasoning, recognized that a lot of creative work had gone into making the selections for the pan and scan version, and indeed, a lot of creative decisions had gone into the making of the pan and scan version, thus it is entitled to copyright protection. Those interested in seeing how a pan and scan version can exhibit creative choices and how the choices are not so obvious because after all, two different attempts at making pan and scan versions resulted in two different choices of what to crop, may want to look at this page at copyrightdata.com, showing comparisons of several scenes as they appear in two different pan and scan versions. Another look at Section 103 might be in order here. We've looked at cases where the later work was in the public domain, with the exception of the McLintock pan and scan version. However, in a reversal of A Star is Born, the books in the Hopalong Cassidy series were copyrighted and renewed, whereas the movies based upon them were not renewed, thereby going into the public domain earlier. In this case, the court determined that the movies could not be shown without violating the underlying rights in the books, and therefore the only parties that could distribute the movies were licensees of the rights holders in the books. When the Supreme Court of the United States dealt with a case involving the movie of Rear Window, the justices pointed out in an opinion that several movies had gone into distribution limbo or were threatened with that possibility, because the underlying works remained under copyright, but those rights were in conflict with rights in the movie versions. When a newer work incorporates portions of an older work, the new work is a conglomeration of aspects of the older works, and therefore the copyright status is a conglomeration of the older works. When comedian Harold Lloyd put together a collection of clips from some of his earlier movies. The copyright notice he put at the end of the movie points up this situation by listing all of the years of copyright of the various works incorporated within the new work, in addition to listing the year of the new work itself. Sometimes it's argued that the maker of a newer work doesn't have to get permission from the rights holders of the older work because what he is doing is considered fair use. That argument has been forwarded in the case of Shepard Fairey's artworks based upon the copyrighted photograph of Barack Obama. Is what Shepard Fairey did entitled to the defense of fair use? That is the subject of another video.